I'm not threatening you. Say one.
And that right there is not a suggestion. That's a judicial countdown. When a judge references 30 days mid-sentence, we're talking contempt power. Courts have the authority to maintain order instantly, and contempt can mean jail on the spot. This isn't about winning an argument anymore. It's about testing authority in real time. Question is, why push it when the stakes are felony level?
More words, and that's 30 days. 30 days!
Right out of the gate, this is not going where the defendant thinks it is. Instead of answering a simple identity question, he pivots into classic sovereign citizen territory, trying to separate himself from the name on the case. That strategy might sound clever online, but inside a real courtroom, judges see it every single day. And watch the temperature in this room. The judge stays patient at first, but the defendant keeps pushing, keeps refusing to engage with basic procedure. That's a dangerous gamble when you're already facing felony charges. Because in this courtroom, word games don't beat judicial authority, and the judge is about to make that crystal clear.
Court calls the case of the people versus Styron. State your name.
My name is Thomas Styron. I live in Maine.
So Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. First count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides...
That's a procedural power move. If a defendant refuses to engage, the court doesn't debate philosophy, it pauses them. Judges are required to ensure a defendant understands the charges, but they are not required to entertain semantic identity arguments. And here's the irony. Refusing to answer simple questions doesn't stop the case. It just removes your voice from it. Strategic or self-sabotage?
He wants to cooperate, we'll bring him back, maybe.
Big mistake. The moment the judge warns him about one more word, that's a flashing red light. Experienced defendants know, when a judge gives a direct warning, the smart move is silence. He doesn't take the hint, and the consequences are already stacking.
I'm not threatening you. Say one more word, and that's 30 days. 30 days! Recalls the case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same.
This is the quiet warning most pro se defendants underestimate. Self-representation is a constitutional right, but it's a brutal one. The court will not explain objections, it will not coach you on evidence, and it will absolutely expect you to know procedural rules. Confidence feels powerful in the moment until legal technicalities start stacking up. Do you think most people truly understand what they're signing up for here?
Standards that I would hold an attorney representing or practicing before this court.
Listen carefully. The judge is laying down the rules of self-representation. No help, no shortcuts. Same standards as a licensed attorney. This is the quiet moment many pro se defendants underestimate. Confidence is high now, but the legal learning curve is brutal.
So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at the first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
Setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment sentence regarding the...
And just like that, contempt becomes custody. Notice how calm it sounds. That's the weight of courtroom authority. Contempt isn't about punishing beliefs, it's about behavior inside the courtroom. Once the judge finds disruption, the sanction is immediate. No dramatic buildup, just consequence. At this point, the dynamic has shifted from argument to enforcement.
Contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of
man,
all,
I'm the
watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a SEC trust matter involved in this? Is my social security number attached to this at all?
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not, in any manner whatsoever,
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve for 30 days. We'll see. See him on the 6th. Bond continued.
In the end, the judge exercised pure courtroom authority, clear warnings, clear consequences, and zero tolerance for disruption. The defendant had choices: cooperate or escalate, and he chose the harder road. 30 days for contempt sends a message. So what do you think? Was the judge right to shut this down fast? Or did the defendant waste his own opportunity? Comment below, hit like, and subscribe for more real courtroom breakdowns.
All right? Don't make me regret it. Do the right thing. You hear me?
You won't. Brian Bowling on behalf of Mr. Smith, Your Honor. Okay, Mark. State your name for the record, please.
Marshan Smith.
Thank you. Judge, we're asking this matter be sent for a preliminary examination.
Discovery is complete.
I believe it is, yes.
People, other witnesses available the 13th?
Yes, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue.
Your Honor, may I address bond?
May.
Your Honor, this is the only matter holding Mr. Smith, to my knowledge. There's a $25,000 bond. He indicates to me that he is employed at Toyota in Saline, which is a very good job. He believes he will lose that job if he remains in custody any longer. Further, it's come to his knowledge that the apartment that his fiance and daughter live in Ypsilanti, that they are going to be evicted from that residence if he's not able to be the financial support for those individuals, which ultimately ties to my early argument regarding his job. He indicates to me
the
that
apartment in his name?
It is.
Yes.
Your Honor.
Who's the landlord?
We just moved there. We moved out of Arbor 1 into this apartment.
What's the name of the apartment complex?
I can't remember.
You just moved out of Arbor 1. How long ago?
Like 60 days. We moved out of Arbor 1 into this apartment. We've been trying.
Because you were trying.
Because it was
a mess
condemned
over there.
Yeah, it was condemned. And we just got this apartment, Your Honor. I don't want to lose it.
Your Honor, just
Okay, have they started? It's in your name?
The apartment is in me and her name, yes.
We don't have anything in his name.
I could try to come up with the lease or something, but if my name is on the lease.
That line is courtroom gold. Translation, you were gaining ground. Don't undo it. Judges appreciate concise answers. Over-explaining can open doors you just finished closing. And the laughter? That's tension breaking in real time. Compare that to the first defendant. Tone, cooperation, posture, completely different energy. Same courtroom, different approach. See the contrast?
Lease with her.
You know when you're winning, you should stop talking.
Sorry.
See, the way he reacted, thank you, sir. If attorneys would react that way, my day would be so much easier. Anything from the people?
Yes, Your Honor. Your Honor, the facts of this case, Mr. Smith was released on a DV case. It's a city prosecution out of Ypsilanti. Several hours thereafter, the police were called because he had contacted the victim's grandmother. The victim's grandmother called the police, indicated that he had told her that he was on his way over and did not care what happened. There was a no contact and a stay away order in place on the domestic violence bond. When he arrived, police had already gotten there. He was observed by the arresting officer standing outside the door. The officer asked him to stop and come and speak to him. He immediately ran. The officer had to chase him out of the building, down the street, through the snow, until eventually he fell down. The officer tased him. He did not stop. Eventually, he was able to take him into custody. The people are very concerned about his refusal to follow the court's orders regarding bond, as well as his refusal to follow the orders of law enforcement.
may I respond to that? Your Honor, it's my understanding that Mr. Smith, regardless of any other calls that may have been made, was he reached out to the Ypsilanti Police Department for a civil standby or civil assist visit at that residence to obtain some items. It's my understanding he was in communication with the Ypsilanti Police Department, actually received a return call from them telling him to go to that location. I mean, ultimately, we're here for the allegations that Mr. Overwater just stated happened once he came in contact with the police at that location. But
what happened to the underlying DB?
It's still pending. There is a personal bond on that case.
So
I believe it was scheduled for a hearing yesterday. And nothing was changed.
So that's what I'm trying to figure out. So if the violation is for the underlying DB, he goes there, which would be a violation on that case, and where you would suspect that his bond would be denied.
Fair enough, but
his bond is not denied. He has a PR on that case, and because, all right.
And I mean, I'm not sure exactly what happened with respect to the
What
call.
did I tell your client?
Great, fair enough.
Okay. I understand the circumstances, but if there's really a safety issue with this individual and not being able to follow the orders, that needs to be taken care of in that other case. As I'm looking at this case, I think his bond is inappropriately set. I'm also, because of his Arbor One situation, I'm a little bit worried if he loses that apartment. He's probably sat in a condemned unit for a number of months, just trying to find a way out. So what I will do is I'm going to grant the motion for a bond reduction. His bond in this case will be.
And here's the balancing act. The court weighs public safety, compliance history, housing stability, employment. It's never just one factor. Despite serious allegations, the judge sees instability risk if bond stays high. That's discretion in action. Courtrooms aren't one size fits all. 2 defendants, 2 attitudes, 2 outcomes. So what's the real lesson here? Law, behavior, or both?
Reduce $25,000 personal recognizance bond.
Thank you. Your Honor.
And thank you.
You're welcome, sir.
Thanks, Jeff.
All right. Don't make me regret it. Do the right thing. You hear me?
You won't, Your Honor.
All right. Take care of yourself.